In recent months, court documents from United States federal courts have begun to expose a strategy that is rarely discussed publicly, yet proves to be extraordinarily effective when deployed by the leadership of Jehovah's Witnesses. This isn't primarily about removing videos. It isn't primarily about copyright enforcement. And it certainly isn't just about protecting content. What emerges from these judicial records is something far more calculated, far more direct, and far more dangerous for those who remain physically inside the organization while mentally awakening to its control mechanisms. The Watchtower Bible and Tract Society of Pennsylvania has been systematically using a provision of the Digital Millennium Copyright Act to obtain, through judicial channels, something very specific: the real-world identities of anonymous individuals associated with alleged copyright infringement involving internal organizational materials. This isn't speculation or paranoid theory. This is documented judicial practice, occurring right now in federal courtrooms across the United States. There exists a verifiable pattern of legal action, registered in federal courts, where the Watchtower has petitioned tribunals to authorize DMCA subpoenas directed at major technology companies like Google and Reddit. Since June of 2017, the organization has filed approximately 60 applications for these subpoenas in New York courts alone. 60 applications. Not 60 lawsuits against infringers. 60 requests for the singular purpose of obtaining identifying information about anonymous users. The mechanics of these cases follow a consistent template. The Watchtower files what is known as an ex parte application, meaning they appear before a judge without the opposing party present or even notified. They request that the court clerk issue a subpoena compelling a service provider to produce identity information about entities or persons believed to be infringing on Watchtower copyrights. The court reviews a declaration, usually from Watchtower attorney Paul Polidoro, along with supporting documents claiming copyright ownership and infringement. If the judge finds the paperwork in order, which typically takes mere minutes, the subpoena is issued. What makes this pattern particularly revealing is what happens next. Or more accurately, what doesn't happen next. According to legal observers who have tracked these cases, including attorneys who have defended targets of these subpoenas, the Watchtower has never used the information obtained from these subpoenas to file an actual copyright infringement lawsuit. Read that again. 60 applications for subpoenas over several years. 0 lawsuits filed using the information obtained. The only copyright lawsuit the organization has filed against a DMCA subpoena target occurred in a case where the subpoena itself was denied by the court on fair use grounds. This creates an uncomfortable question. If the stated purpose of these subpoenas, as declared under oath to federal courts, is to obtain identity information solely for the purpose of enforcing copyright protections through litigation, why does litigation never follow? The pattern suggests an entirely different objective. To understand why this tool is so powerful, you need to understand how fundamentally different it is from normal legal processes. The Digital Millennium Copyright Act, passed by the United States Congress in 1998, contains a provision under Section 512H that creates an extraordinary shortcut for copyright holders. Under normal circumstances, if you want to compel someone to reveal information through the legal system, you must first file a lawsuit, establish jurisdiction, demonstrate standing, and then during the discovery phase of that lawsuit, you can issue subpoenas to third parties. The DMCA subpoena process inverts this entirely. Under 17 U.S.C. Section 512H, a copyright holder can request that the clerk of any United States District Court issue a subpoena to a service provider for identification of an alleged infringer without filing any lawsuit whatsoever. No complaint. No judge's review. No adversarial process. Just a filing with the court clerk. The requirements are minimal. The copyright holder must file 3 things with the clerk. First, a copy of a DMCA takedown notification that complies with Section 512(c)(3)(a), identifying the copyrighted work and the allegedly infringing material. Second, a proposed subpoena form indicating what identifying information is sought. And third, a sworn declaration stating that the purpose of the subpoena is solely to obtain the identity of an alleged infringer and that the information will only be used for the purpose of protecting rights under copyright law. That's it. No hearing. No opportunity for the anonymous user to object before the subpoena is issued. No judicial scrutiny of whether fair use might apply. The filing fee is less than $50. The clerk reviews the paperwork for completeness, signs the subpoena, and it can be served on the service provider, who is then legally obligated to comply unless they choose to mount a legal challenge themselves or the target files a motion to quash. This creates a pathway where, instead of simply removing content, the copyright holder can potentially obtain data linking an account, an upload, a comment, or a shared link to a real person. And depending on the type of account and how it was used, the identifying information can include names associated with the account, email addresses linked to registration, telephone numbers, payment information if the account had any premium features, and critically, IP addresses and metadata from access logs that can help reconstruct not just who, but from where, when, and how someone accessed the service. The United States Copyright Office itself explains that once a subpoena is issued under this provision, it authorizes and orders the service provider to expeditiously disclose information sufficient to identify the alleged infringer. For major platforms like Google, which operates YouTube, this can mean turning over comprehensive account registration data, usage logs, and technical metadata that, when pieced together, can definitively link an anonymous username to a flesh-and-blood person with an address, a family, and a congregation. Here is where the strategy becomes clear, and where it becomes particularly insidious for a specific subset of people. The primary targets of these identification efforts are not the prominent critics who already operate publicly under their real names. The organization already knows who those people are. They've already been disfellowshipped. They've already lost their families. They've already paid the social price for their dissent. The strategic target is someone else entirely. The target is the anonymous internal source. The PIMO individual. PIMO stands for physically in, mentally out, a term used widely in online ex-Jehovah's Witness communities to describe people who no longer believe the organization's teachings but continue attending meetings, going in field service, and maintaining the appearance of faithfulness. They do this because leaving openly would mean immediate social death. Their parents would be required to shun them. Their spouse might be pressured to divorce them. Their children, if still believers, would be taught to view them as spiritually dead, as having chosen Satan over Jehovah. These individuals represent a different category of concern for organizational leadership than an ex-member with a public platform. A person who no longer attends but who comments publicly is operating in the open. But someone who still has internal access to documents, to correspondence, to procedures, to meetings, represents a different kind of information source. They can potentially provide materials before they're officially released. They can document internal processes. They can offer real-time information about organizational changes or policy discussions. From an organizational perspective, external commentary is one thing. Internal documentation is another. The distinction matters because documents can be verified, can be used as evidence, can substantiate claims that might otherwise be dismissed as subjective criticism. The cases that have become public reveal this pattern clearly. Consider the case of a Reddit user known as Dark Spilver, a self-described lifelong member of the Jehovah's Witness community who participated in discussions on the XJW subreddit. In early 2018, Dark Spilver posted a scanned image of the back page of a Watchtower magazine that contained a donation request, and separately posted a chart showing data collection categories used by the organization. Watchtower filed for a DMCA subpoena to force Reddit to reveal Dark Spilver's identity. When this became public, the Electronic Frontier Foundation took up Dark Spilver's defense, arguing that the posts constituted fair use and that unmasking Dark Spilver would expose them to disfellowshipping and subsequent shunning by family and community. The court documents in that case revealed that Dark Spilver lived outside the United States but participated in an online community with substantial U.S. membership. Watchtower's attorneys argued that because Dark Spilver was foreign, they lacked First Amendment protections. The court rejected this argument, finding that the First Amendment applied because the subpoena was issued in a U.S. court, directed at a U.S. company, on behalf of a U.S. organization, targeting content consumed by a U.S. audience. Ultimately, the magistrate judge crafted a compromise ruling that revealed the true danger of these proceedings. The judge partially granted the subpoena but imposed strict conditions. Reddit would provide Dark Spilver's identifying information, but only to Watchtower's attorneys, under an attorney's eyes only restriction. The information could not be shared with Watchtower's staff, its client representatives, or even expert witnesses without further court approval. If Watchtower chose to file a lawsuit, it would have to proceed under a pseudonym with Dark Spilver's real identity kept under seal. What's revealing is what happened after that ruling. Watchtower obtained the identity but never filed any copyright infringement lawsuit. The case simply ended. But Dark Spilver's fear of being identified to the organization was not irrational paranoia. It was based on documented organizational practice of subjecting questioners and critics to internal judicial processes that result in disfellowshipping and mandatory shunning. This is the crucial point that makes this strategy particularly devastating for PMOs. The value of obtaining someone's identity through legal process isn't primarily about pursuing a lawsuit. It's about feeding that identity into the organization's internal disciplinary system. Once a PMO's identity is confirmed, they become vulnerable to something far worse than legal action. They become vulnerable to a process that has destroyed countless families and relationships, a process that operates entirely outside the judicial system and carries no legal penalties but can inflict profound personal devastation. The path is well documented by those who have experienced it or witnessed it firsthand. Once the organization has a name and can confirm the person is or was a baptized Jehovah's Witness, the investigation begins. Elders in the person's congregation are notified. Evidence of their apostasy is compiled. This might include their anonymous posts, their leaked documents, their critical comments, or simply their association with ex-member communities. The person is contacted and invited to meet with a judicial committee, typically 3 elders who will review the evidence and determine whether they have engaged in conduct warranting disfellowshipping. The judicial committee process is not a trial in any legal sense. The person has no right to legal representation. The proceedings are confidential and transcripts are not provided. The standards of evidence are internal and religious, not legal. And most critically, if the committee determines that the person is guilty of apostasy, which the organization defines broadly to include not just teaching contrary doctrine but even privately disagreeing with organizational teachings, the punishment is predetermined: disfellowshipping and mandatory shunning. What does shunning mean in practice? It means that every Jehovah's Witness who knows you, including your parents, your siblings, your adult children, your lifelong friends, are required to cut off normal association with you. They will not eat meals with you. They will not socialize with you. They will not attend your wedding or celebrate your achievements. If you attend meetings, they will not greet you or converse with you beyond minimal necessary interaction. For someone whose entire social network, whose entire support system, whose entire conception of family and community has been within the organization, this is social death. This is why identification through legal process is so powerful and so terrifying. It's not the legal consequences that matter. Watchtower rarely pursues actual copyright litigation. What matters is that the anonymous critic who thought they were safely separated from their physical identity can suddenly find themselves called before elders, confronted with printouts of their Reddit posts or leaked documents they shared, and faced with an impossible choice: recant, apologize, promise to cease all critical activity and turn over any other PMOs they know, or lose everyone they love. The organization doesn't need a court judgment. It doesn't need monetary damages. It doesn't need an injunction. It needs the name. Once it has the name, the internal machinery takes over, and the result is often more effective at silencing dissent than any legal penalty could be. To understand how this identification strategy functions at scale, you need to understand that it operates within a broader monitoring infrastructure. The DMCA subpoena is the legal tool, but it requires first identifying which anonymous accounts are worth targeting. This requires surveillance of the spaces where ex-members, PMOs, and critics congregate and share information. Reports from activists and those who track these patterns indicate that Watchtower systematically monitors online forums, particularly Reddit's XJW community, YouTube channels that discuss organizational issues, websites that host leaked documents, and social media platforms where internal materials might be shared. This monitoring serves multiple purposes. It identifies when copyrighted materials are being shared, providing the basis for DMCA takedown notices and subsequent subpoenas. It identifies patterns in what information is leaking and when, potentially helping to narrow down which congregation or which group of insiders might have access to particular documents. And it creates a database of anonymous usernames and accounts that can be cross-referenced against other information to build identification profiles. The Internet, particularly for people who don't use sophisticated anonymity tools, is not a place without traces. Every post has metadata. Every upload has timing information. Every comment can be cross-referenced with other posts from the same account. A person might use a pseudonym on Reddit, but if they've also commented on YouTube using a different username, and those two accounts show similar patterns of interest, similar timing of activity, similar language patterns, or reference similar personal circumstances, the accounts can potentially be linked. If one of those accounts is less anonymous, perhaps using a real name or connected to other social media, suddenly the Reddit pseudonym is no longer anonymous. When Watchtower files a DMCA subpoena and obtains account information from Google or Reddit, that information can include not just the registration email, but IP addresses from login sessions, device identifiers, timestamps of access, and other technical data that can be correlated. If someone posted a leaked document from an IP address that traces to a specific geographic area, and the organization knows that document was only sent to a particular set of congregations or only accessible to elders in a certain region, the universe of possible leakers suddenly becomes very small. This isn't theoretical. In at least one documented case, a blogger who had been critical of Watchtower's handling of child sexual abuse was identified through DMCA subpoena process despite using a pseudonym. According to attorneys familiar with the case, Watchtower obtained the blogger's identity but never sued for copyright infringement. The blogger was subsequently subjected to congregation discipline. The organization got what it wanted, the person's identifying information delivered through legal process, which then enabled internal action. The cost was less than $50 in court fees. No lawsuit necessary. No public trial. No risk of adverse publicity. Just quiet identification followed by internal proceedings that most of the public never hears about. What makes this strategy particularly effective is that it exploits vulnerabilities in how the DMCA was designed. The statute was created in 1998, at a time when Congress was primarily concerned with large-scale commercial piracy and peer-to-peer file-sharing networks. The expedited subpoena process under Section 512H was intended to help copyright holders quickly identify and sue commercial infringers who were profiting from pirated content. The drafters of the law did not anticipate that this mechanism would be used by organizations to unmask anonymous critics and internal whistleblowers who share materials for purposes of commentary, criticism, and public interest journalism. They did not build in robust protections for fair use, which is supposed to permit the use of copyrighted material for transformative purposes like criticism and commentary. They did not require any judicial review before a subpoena is issued. They did not require the copyright holder to demonstrate that litigation is actually intended or likely. The statute requires only that the copyright holder declare under oath that the information will be used solely for the purpose of protecting copyright rights. But how is that enforced when the organization never files a lawsuit? How is it enforced when the true purpose appears to be feeding information into a religious disciplinary system rather than pursuing copyright enforcement? Courts have begun to recognize this problem, but the legal framework remains largely unchanged. In several cases where targets of Watchtower subpoenas have obtained legal representation, judges have expressed skepticism about the organization's motives. In the Kevin McFree case involving the Dubtown stop-motion animations, the court noted that Watchtower had filed nearly 60 DMCA subpoena applications but had never followed them with infringement lawsuits. The judge questioned whether the declarations about using information solely for copyright enforcement were being made in good faith. But skepticism from judges doesn't change the fundamental structure. The subpoena still gets issued. The service provider still has to comply or mount an expensive legal challenge. The anonymous user still gets unmasked, unless they can afford legal representation and successfully argue fair use before their identity is revealed. For most people, particularly those still inside the organization who fear exposure, mounting that kind of legal defense is impossible. They can't hire an attorney without explaining why they need one. They can't go public without losing the very anonymity they're trying to protect. They're trapped. This entire mechanism has profound implications for transparency and accountability within high-control religious organizations. One of the few checks on organizational abuse and misconduct is the willingness of insiders to come forward with evidence. Investigative journalists rely on confidential sources. Advocacy organizations rely on whistleblowers. Legal proceedings rely on witnesses willing to testify about what they've experienced or observed. When an organization can systematically identify and punish internal sources through a combination of legal process and religious discipline, it creates a chilling effect that extends far beyond the individuals directly targeted. Every PMO who considers sharing a leaked document or recording of a judicial committee must weigh not just whether they'll be caught, but whether the organization will use legal mechanisms to identify them even if they take precautions to remain anonymous. This affects what information reaches the public. It affects what evidence becomes available in child sexual abuse cases, where internal organizational documents about how abuse allegations are handled have proven crucial to holding the organization accountable. It affects what current members learn about organizational finances, leadership decisions, policy changes, and internal controversies. It concentrates control over information in the hands of the organization's leadership, allowing them to manage narratives and suppress dissent more effectively. The Watchtower organization has a documented history of making claims in public that are contradicted by internal documents. They have claimed cooperation with authorities in abuse cases, while internal letters instructed elders not to report unless legally required. They have claimed financial transparency while maintaining secrecy about organizational assets and expenditures. They have claimed that judicial committees are fair and loving, while internal manuals describe procedures designed to extract confessions and identify other potential apostates. The only reason these contradictions become known is because people inside the organization, often at great personal risk, choose to share what they know. When those people can be identified through legal process and subjected to social death through disfellowshipping, the flow of information slows or stops. The organization becomes less accountable. Abuse victims have less access to evidence. Families have less information to make informed decisions about remaining in or leaving. The public has less understanding of how these organizations operate and what harms they may be causing. For individuals who find themselves in situations where they need to protect their privacy online, particularly when dealing with organizational environments that may monitor digital activity, understanding digital security has become essential. The landscape of online privacy has changed dramatically over the past decade, and approaches that once provided adequate protection may no longer be sufficient. It's important to understand what information service providers collect as part of their normal operations. When you create an account on any platform, that platform typically collects registration data including email addresses, and in their server logs they maintain technical information like IP addresses, device identifiers, and timestamps of access. This is standard practice across the internet and is disclosed in terms of service agreements. What many people don't realize is that this data can be subject to legal process, including subpoenas, even if the account was created under a pseudonym. Privacy advocates and digital security experts consistently emphasize that maintaining anonymity online requires more than simply using a username instead of a real name. It requires understanding how data can be correlated across different platforms, how metadata in documents can reveal identifying information, and how patterns in online behavior can create digital fingerprints. Tools like VPNs and Tor exist specifically to help protect privacy, and learning to use them correctly is part of responsible digital citizenship in an age of increasing surveillance. For anyone concerned about privacy in any context, whether related to religious organizations, employment situations, or other circumstances, the general principle recommended by privacy advocates is this. If you have information you believe serves the public interest, consider working with established journalists or advocacy organizations who have experience protecting source confidentiality. This is standard practice in investigative journalism and whistleblower protection, and it exists precisely because maintaining true anonymity while directly publishing information yourself is technically complex and easy to compromise inadvertently. Instead, the safer approach is to provide information to activists and journalists who are already publicly known, who have already left the organization, and who have already paid the social cost of their dissent. These individuals can serve as intermediaries, protecting source identity while still bringing information to public attention. They can receive documents, verify their authenticity, and publish or share them under their own names, shielding the source from exposure. This isn't cowardice. This is strategic preservation of sources so they can continue providing information over time rather than being identified and silenced after a single disclosure. It's how investigative journalism has always worked. Deep Throat didn't create his own anonymous blog to expose Watergate. He provided information to journalists he trusted, who protected his identity for decades while using the information to hold power accountable. For those determined to create their own platforms or channels to share information, the risks must be clearly understood. Every public post is data. Every video is metadata. Every document shared has properties that might reveal when it was created, who had access to it, or where it came from. And underlying all of this is the knowledge that the organization monitors these spaces, identifies content that involves their copyrighted materials, and has a demonstrated willingness to use legal process to unmask anonymous critics. This strategy of using legal mechanisms to identify and silence critics is not unique to Jehovah's Witnesses, though they have refined it to an unusual degree. It represents a broader pattern visible across various high-control organizations, corporations, and institutions that face criticism or internal dissent. The fundamental principle is the same. When you can't defeat the message, attack the messenger. When you can't refute the evidence, eliminate the source. When you can't win in the court of public opinion, use the actual courts to obtain identifying information that enables non-legal forms of retaliation. For religious organizations specifically, this creates a two-tier system of accountability. Organizations that don't practice shunning, that don't threaten social death for dissent, that allow members to question and disagree without existential consequences, face normal market pressures. If their critics are right, people leave. If their practices are harmful, membership declines. If they hide misconduct, whistleblowers come forward without fear. But organizations that do practice mandatory shunning, that do threaten complete social isolation for disagreement, that do teach members that questioning leadership is equivalent to questioning God, can use legal identification mechanisms as a force multiplier for social control. The threat of being unmasked and disfellowshipped becomes a powerful deterrent against speaking out, even when someone has witnessed abuse, even when they have evidence of misconduct, even when they know the organization is lying publicly while maintaining different standards internally. This isn't just about copyright law or internet anonymity. It's about power, control, and the lengths to which institutions will go to protect themselves from accountability. The DMCA subpoena is simply a tool, a means to an end. The end is the preservation of organizational control over information and the suppression of dissent through social mechanisms that leave no legal remedy and no public record. This is not speculation. This is not conspiracy theory. This is documented practice occurring in federal courts under established legal mechanisms. The Watchtower Bible and Tract Society has filed dozens of applications for DMCA subpoenas since 2017. These applications have resulted in the issuance of subpoenas requiring technology companies to disclose identifying information about anonymous users. The organization has declared under oath that this information will be used solely for copyright enforcement. Yet in the overwhelming majority of cases, no copyright lawsuit ever follows. The logical conclusion is that the primary value of these subpoenas is not legal enforcement but identity acquisition for purposes of internal organizational discipline. The goal is not to win copyright cases but to identify PMOs, internal critics, and sources of leaked information so they can be subjected to judicial committees and disfellowshipping. For those still inside who are considering sharing information they believe the public should know, the operational reality is clear. The organization monitors online spaces where ex-members congregate. It identifies copyrighted content being shared. It files for legal subpoenas to unmask those sharing it. It uses the information not for lawsuits but for identifying members who can then be subjected to internal discipline and mandatory shunning. The pattern documented in court records raises questions about the relationship between legal mechanisms designed for copyright enforcement and their application in contexts involving religious organizations that practice shunning. When subpoenas are granted but litigation rarely follows, when identifying information is obtained but copyright cases aren't filed, observers are left to analyze what purpose these legal tools are actually serving. For individuals who may find themselves in situations where organizational monitoring could affect their privacy or their standing within religious communities, understanding how these mechanisms work is not about paranoia. It's about informed decision-making. It's about understanding that the digital age has created new intersections between legal process, technology platforms, and organizational discipline that didn't exist a generation ago. The documentation exists in public court records. The legal framework is established in federal statute. The consequences for those identified through these means are documented in the experiences of those who have gone through organizational judicial processes. What remains less visible is the full scope of how these elements interact, how many people have been affected, and what information about organizational operations might remain undisclosed because potential sources understand the risks of sharing it.